As I mentioned earlier, we're now 2 years and 2 months in, or 2 years and 1 month into the lawsuit. SEC filed suit against us, saying that our sales of XRP represented sales of unregistered securities.
Do you think the long-standing lawsuit between the US and Ripple will end with the SEC simply settling with the firm? It is no secret that Ripple CEO Brad Garlinghouse previously expressed the company's willingness to settle with the SEC, but that the regulator's view on crypto made that impossible to happen. Now, do you think that the SEC will settle with XRP? In a recent tweet, Twitter user HFintech said, "A joint request. Discussions are continuing and the SEC has no choice but to settle or lose." However, another Twitter user replied that he doesn't see this coming. SEC will not settle. The Hinman documents may be embarrassing, maybe a temporary black eye for the SEC, but I don't believe they throw away the whole case to keep those emails and documents hidden. Call me crazy, I don't see it. They could have filed for a reconsideration. What do you think? Speaking of a settlement, Ripple's top executive has notably expressed that the firm is open to settling the case. However, the SEC and its chairperson Gary Gensler's view of crypto in general is a huge roadblock to that intent. You all know what the issue is about. The US SEC filed a lawsuit against Ripple in December 2020 for allegedly selling unregistered securities, claiming that XRP is a security rather than a commodity. Of course, there are two sides to the story here, figuratively speaking, that of Ripple and that of the SEC. Now, in the absence of legislation that makes clear the classification of crypto assets in the US, the question of whether they should be treated as securities have to be assessed on a case-by-case basis through the application of the Howey test. When the SEC charged Ripple and its executives, it declared that XRP met these criteria and that by raising funds through the sale of XRP, the company was in violation of federal securities law. Although Ripple is not the issuer of XRP, some of its executives were part of the group that developed the token. In light of this, Ripple is challenging the SEC's analysis on two fronts. It is arguing that its sale of XRP does not qualify as an investment contract, because no contracts were signed when the transactions took place, and separately, that XRP does not satisfy the prongs of the Howey test. Stuart Alderati, chief legal officer at Ripple, says the company is certain that XRP does not meet any of the Howey criteria, but that it is particularly confident that there is no common enterprise, a group undertaking that affects the fortunes of XRP investors among XRP holders, only common interest. However, a recently made public SEC staff email revealed that XRP failed the Howey test. Notably, the Howey test is the strongest point the SEC is using against Ripple, because it is a well-established test for determining whether an investment contract constitutes a security under the Securities Act of 1933. However, the test has limitations, and there are several ways in which it might come up short in the case against Ripple. Now, as you all know, the U.S. District Court for the Southern District of New York is yet to deliver a judgment on whether Ripple's XRP can be considered a security. In the meantime, the attorney representing XRP holders in the crucial Ripple lawsuit made a huge claim on the nature of the XRP token, based on the SEC's staff submission. Attorney John Deaton, amicus curiae in the XRP lawsuit, highlighted a footnote from Ripple's opposition and reply briefs submitted in the court. It stated that there are reasonable grounds to conclude that XRP does not satisfy all the elements of the Howey analysis and is therefore not a security for purposes of the federal securities law. Exhibit 230 also stated that it is more likely than not that XRP will not be considered a security, and thus it should not be subject to regulatory oversight by the US SEC. Note that mentioned statement is from Exhibit 220, which is a part of the SEC emails. In light of this, it is a vital concern as to why the Commission alleged charges against the Ripple executives when its staff analyzed that XRP is not a security in nature. Adding further to the claim, the pro-XRP lawyer pointed out that on June 13, 2018, the SEC enforcement lawyers penned down a note analyzing XRP. However, the Commission did not recommend any enforcement, including a cease and desist letter to halt trading of the token. So, what does the email say? There are reasonable grounds to conclude that XRP does not satisfy all elements of the Howey analysis, and is therefore not a security for purposes of the federal securities laws. The email reads, "The SEC case against Ripple is hinged on the argument that XRP and most cryptocurrencies should be classified as securities because they meet the definition of the term under the Howey test. Thus, any admission by the SEC or its official that XRP does not constitute a security in its internal documents could be disastrous to its case." Deaton suggested that it was likely that the statement was not a direct quote from an SEC official, and that the official could be referencing someone else's analysis of XRP. This idea was supported by another pro-crypto lawyer, Bill Morgan, who said an SEC attorney most likely sent the email. Morgan said, "Most likely a SEC attorney, given how many were involved, and commented on Hinman's speech expressing his personal opinion." In relation to the Hinman speech, as recently reported, Judge Annalisa Torres ruled on the parties' request to seal documents related to summary judgment motions and accompanying exhibits. The most important aspect of the ruling was the denial of the SEC's motion to seal internal deliberations related to Hinman's 2018 controversial speech, popularly referred to as the Hinman Docs. Following Judge Torres's decision, the parties were required to release the documents on June 6, 2023. However, both the SEC and Ripple requested a one-week extension to the deadline. Although Judge Torres granted the request almost immediately, XRP community members engaged in a heated debate over the weekend about why the parties requested a one-week extension to release the docs. Some argued that the delay would give the parties more time to discuss the terms of a possible settlement. However, other enthusiasts like Deaton think the delay was necessary due to the voluminous nature of the documents the parties need to file following the sealing order. Aside from speculations, there is no official date Judge Torres is expected to make a summary judgment decision. While Ripple CEO Brad Garlinghouse speculated that the case would be resolved before the end of September 2023, the blockchain company asserts the summary judgment will come before the end of the year. It bears mentioning that the exact date on when the summary judgment will come is entirely up to Judge Torres. However, what probably came as a shock to many was the most recent development on the case, where one of Ripple's lawyers filed a motion to withdraw from the SEC lawsuit. As the SEC versus Ripple lawsuit approaches its end, attorney Kylie Chisel Kim, one of the lawyers representing the blockchain company, has filed a motion to withdraw from the case. The development was shared yesterday by seasoned pro-XRP lawyer James K. Fillon, who has closely followed the ongoing SEC versus Ripple litigation. According to documents shared by Fillon, attorney Kim filed the motion in the Southern District of New York only a few days ago. In the motion, Kim noted that she would no longer be associated with Kellogg, Hansen, Todd, Feigl, and Frederick PLLC, the law firm currently representing Ripple in the ongoing SEC legal battle. The document also clarified that other lawyers from the law firm and Debevoise and Plimpton LLP would continue to represent the leading blockchain company throughout the lawsuit. Attorney Kim also attached her declaration to the recently filed motion. It is worth noting that Attorney Kim joined Ripple's legal team in July 2022. As reported, the development was seen as an important step towards strengthening Ripple's legal team in the fight against the U.S. Securities and Exchange Commission. In light of this recent development, the XRP community members have been asking what could have prompted her decision to exit the lawsuit, especially when Judge Torres is expected to make a summary judgment decision at any time. Many XRP enthusiasts are bothered about how the move could affect the upcoming summary judgment verdict. For some Twitter users, Attorney Kim withdrew as counsel to Ripple because the case might have been concluded. However, the consensus appears to be that she is withdrawing as Ripple's counsel following her exit from the Kellogg law firm. For now, we can only wait to see if Ripple CEO Brad Garlinghouse's prediction that Judge Annalisa Torres would make a summary judgment decision before the end of Q3 2023 would prove to be correct. According to Garlinghouse, the case has been fully briefed and the judge has all the necessary information to issue a final verdict. As of now, it is unclear why Garlinghouse believes the lawsuit will be resolved in weeks and not months. But then again, all you can do for now is wait for the judge's verdict of the case, whatever that may be. Make sure to subscribe for more of this content.